Thank you all for joining us with Voters East of the Industrial Canal. My name is Dawn Abear, and I'm a member of Voters East of the Industrial Canal. So we're going to get started. I'd like you to tell us your full name, your profession, how long you've been in that profession, what position you are seeking, and your ballot number. Mr. Singer.
Oh, okay. I thought Ms. Lombard should go first, but that's fine.
Okay, we'll let Wanda go first.
Let Ms. Lombard go first.
Okay, Wanda.
Okay. My name is Wanda Marie Lombard. I have been a practicing attorney for 22 years next month. I was sworn in October of 1998. I have primarily practiced criminal law for over 16 years. I sat 5 years as a criminal court magistrate commissioner, and I am now running for criminal court magistrate judge. My number is 99 on the ballot.
Thank you, Ms. Lombard. Mr. Singer.
And good evening. My name's Stephen Singer. I've been a practicing attorney since 1989, so a little over 30 years. All of that time has been as a public defender or an indigent defense. I was a law professor at Loyola Law School, where I ran a criminal defense clinic, which took actual indigent cases in Orleans Criminal District Court. I led the reform and rebuild of the Orleans Public Defender's Office post-Katrina and transformed the office. And I'm running for magistrate judge, just as Ms. Lombard is. Oh, and I'm ballot number 100.
Thank you very much. I want to introduce both of you to Donna Glapion and Brandon Gilmore, who's with You're Going to Feel Me Now podcast. So we'll start with the questions. Thank you.
Good evening, folks. We'll ask that you answer the questions in this order, Ms. Lombard and then Mr. Singer. My first question is a matter of due diligence. Have you ever been disciplined by the bar, arrested, or owed child support?
No, no, and no, I've never been disciplined by the bar. I've never been arrested, and I do not owe any child support.
Thank you, ma'am. Mr. Singer?
Nope, never been disciplined by the bar and never owed child support.
Okay. Next question. Ms. Lombard first. How would you make sure that there is oversight in order to avoid judicial delay?
I'm sorry.
Her screen has frozen on my screen.
Yep, it has.
She
Well, let's
probably
go.
move to
Mr.
get it.
Singer, if you would answer. Do you need me to repeat the question?
You want me to go?
Yes, sir, please do.
Okay. Yes, if you could repeat it.
Absolutely. How would you make sure that there is oversight in order to avoid judicial delay?
I think the most important thing is to be a presence at the court. Currently, the current magistrate judge sits 1 day a week on Wednesdays, and all of the rest of the days, including the weekends, are handled by the commissioners. And I think that's insufficient in terms of oversight and making sure that the court moves smoothly and efficiently. I will say also that I think the other solution to the problem is I think the chief magistrate judge should sit longer, should not just do morning first appearances, but should do morning and afternoon first appearances and sit for a full day, at least 9 to 5, just like everyone else works in the workplace, if not longer. So I think that those are two things that would go a long way. The other thing I just want to add as far as delay goes is I think the most important thing is not how fast things move in court, but how thoroughly and how well things are done in court. So, and I think the solution to that problem is for judges to sit longer hours, not move through the docket more quickly in a shorter amount of time in order to get off the bench. currently at Orleans Criminal District Court, if you go there in any afternoon after 12:30 or 1, the place is like a ghost town. And I just think that's wrong. I think judges should not leave the bench that early. So the key is not faster, but spend more hours, do things more deliberately and better, and do justice for everyone in the case, and spend more time if necessary. And if that means working longer hours in order to get through the same or more cases in order to avoid delay, then that's what should be done. Are we able to get Ms. Lombard back?
She's trying to reconnect.
Yeah, let's
Fine,
definitely give her
fine.
let's
We'll
definitely
just-
give her a chance.
Okay, but we can go on with you.
Okay,
I'll ask you the next question.
sure.
How were you different from your opponent, and what plans do you have for your first 100 days on the bench?
I think the main difference between myself and my opponent is that I'm a reformer. I'm an agent of change. I came in and took over the public defender's office post-Katrina, and I completely revamped it and redid it and restructured it and overhauled it from the ground up. When I took over, there was one chief, 4 or 5 lawyers, and 1 administrative person in a single room in the courthouse with virtually no technology or modern equipment for a modern law office. And within 3 years, we had 55 lawyers, 120 employees, full complete office space, networked laptop computers. So, and we had complete full vertical representation of cases from beginning to end by one person. So I would regard myself as an agent of change. And I think in terms of record, I have an unmatched record for bringing major change and reform that I don't think any of the candidates can match in terms of really bringing real change to the criminal justice system. And I think that's what's needed over at the court. I think if this summer's events and recent events show, we have a system that we have a criminal system that's infected by racism and sexism and classism. And it doesn't need just a few little minor tweaks in order to make it okay. It needs some major change. And I've been there and done that and done it successfully. And the public defender's office here is now went from being regarded as one of the worst public defender offices in the country to one of the best public defender's offices in the country, and a model for how to bring change and transformation to the criminal justice system. And I think that's what's necessary at courthouses. And this is not specific to Orleans. We're talking about courthouses across this country need big change.
Time.
Sure. Thank you, Ms. Glapian.
I'm sorry, I didn't hear that question.
I'll ask you the 2 questions that I asked Mr. Singer in the same order. Ms.
Okay.
Lombard, first question, how would you make sure that there's oversight in order to avoid judicial delay?
Well, as a magistrate, I ran a very efficient courtroom. I stayed on the bench as long as I needed to. I set matters out with a specific date, many times at arraignment. For example, at that time, if I needed to hold a reduction hearing, I might set the reduction hearing for the very next week to avoid the delays at that time that came with being a magistrate commissioner when you only set a week, in order to avoid having people have to wait a week to file a motion and then wait a week to get heard. But I would often give the public their motions, anything they requested for a motion hearing right there at arraignment, because there is no need really to come back to, and I will let them file an oral motion and then can file the written. Also, when I was a magistrate, we used to work together to take each other's motions, so that if somebody wanted to file a motion on a Thursday to be heard on a Monday, Jonathan Freeman might take my motion, or if somebody wanted to file a motion on a Monday to be heard on a Wednesday, I would take a motion for Bob's court and schedule it. And I would definitely, as chief magistrate, reinstate that policy. I've heard that that's changed since I've been gone, but that's one way to keep, especially in a system where everybody doesn't sit every day, is to keep it moving. Secondly, the magistrate, as chief magistrate, needs to always take responsibility for moving the docket of magistrate, setting speedy misdemeanor trials, setting quick hearing dates. There's no reason why a chief magistrate for every magistrate commissioners that those dockets are always moving. And ultimately, you put on a tickler system. I used to have status conferences and ticklers to make sure that I knew that the DA's office wasn't letting people's cases just go on forever. I would have them come in and do a status conference with the DAs, which now DAs aren't magistrate, but back in magistrate, I would be the DAs be back in the section for first appearance. But we would have them come in and I would literally say to them, what is this case? It's been 60 days. This is
that's time, Ms. Lombard. We have to go to the second question. Thank you. Just 1 second.
I ran into time too, so.
Yes. So the second question, Ms. Lombard, how are you different from your opponent, and what plans do you have for your first 100 days on the bench?
Oh no, is she locked up again?
Ms. Lombard, can you hear us?
Oh boy.
Okay. We're going to move on to the third question for you, Mr. Singer.
Sure.
Hold on. You want me to put you on, Donna, hold up a second.
Okay.
I can put you on the phone, on the speaker. You want to do that? So you can answer that second question. Mm-hmm.
My internet just keeps going in and out, in and out.
Okay, Don, yes, that second question.
Okay, the second question is, first of all, what differentiates us is that I have experience doing the job. I understand how the court system works. I understand that to be a good judge, you must be fair, impartial, balanced, and treat everyone with dignity and respect. Two, I am not making promises like my opponent that I cannot keep. I'm not running around the city telling everyone that I'm going to end money bill now, which is what he's been doing for the past 2 months. Even though
he, in fact, cannot, because that is a job that only the legislature can achieve. Three, I have a plan to, one, create a pre-diversion system. I feel that diversion is something that the DA's office has had. It is a tool they've had at this for years, and they've only given it to the privileged few. So I plan to create a pre-diversion system coming straight through the pretrial system at bail, where people that are qualified for diversion can go into a pre-diversion system. They can start the same counseling and the same program that the DA has been using for years to give to the select. So when the time comes to go to a trial section, the DA doesn't really have an excuse for not letting these people. The key to diversion and going to trial is complete diversion successfully, get the conviction. That is a program that is assigned for offenders, and it should be. The other thing is, I think we both want to expand pretrials. We both recognize the need for more options and more options for mental health. But I think that my defense heavy and I am more balanced. I not only want drug treatment and mental health treatment, I want to add victim services. I've worked with human trafficking victims for the past 4 years. I want screening to determine if some of these defendants may also be victims of trafficking, of child abuse, because defendants that I've run across in my career also been victims.
I think we'll keep her on the phone when I get her again.
If you tell her, Ms. Dawn, if she just connect without the video, it may work better.
It may work better, correct, because it'll use less bandwidth.
Yeah.
that the public defenders had the right to go talk to the people in the box before court, before they were distracted. They could privately counsel their clients. And I believe that is definitely one of the things I'm going to go back to in the first 100 days, along with holding court every day. When I was a magistrate, we set the times of day.
All right, Juan. Okay, time is up for you. We got to get to the next question, but hold on. Okay, Donna.
Next question is can she hear? The next question is, what is your opinion reference to the Black Lives Matter movement? Ms. Lombard first, please.
I'm sorry, what was the question?
What is your opinion relative to the Black Lives Matter movement?
What is your opinion relative to the Black Lives Matter movement?
Well, since I'm Black and all 5 of my children are Black, and every one of my ancestors are Black. Obviously, I feel that Black Lives Matter.
I respect the fact that the movement is happening, but I regret the fact that it has to. Like, my opinion is this should not be so much of a discussion. Like, when is society going to wake up and realize that we are a part of society and we shouldn't have to walk around and tell you that our lives matter? That should just be common sense, human dignity. I just don't get why we have to keep restating this over and over again and reasserting the same rights that my mother and them were asserting in the 60s. So yes, obviously I agree that Black Lives Matter, because I feel that my life matters, everybody on the phone's life matter, but I also feel that it's ridiculous that in 2020, we still have to fight these same battles that we've been fighting for 50, 60 years.
Thank you. Mr. Singer?
I don't think there's a bit of daylight between Ms. Lombard and I on this issue. I think it is ridiculous that people have to march and people have to go out in the streets in order to try and convince other people that they are people and deserve to be treated like human beings. And that goes for 95 to 99% of the clients I've represented over my 30-year career have been Black and African-American, and it goes for victims of crime who are Black, who needed to be treated with respect and dignity throughout the system and throughout society. I do think that one of the important things is that and one of the things that I think is gratifying about the protest movements that have recently occurred is that for the first time you see a majority of Americans, including white Americans, Asian Americans, Americans who aren't Black, joining in the movement. And I think that that's very important in terms of making it not just a movement of people who are Black pushing from the outside in, but to have people who are on the inside also pushing and lifting with them. So I think that that's very important, that people who aren't Black, like me, be standing side by side, shoulder to shoulder with the Black Lives Matter movement. But I don't think there's a bit of daylight between myself and Ms. Lombard on that. She comes to her views extremely genuinely and has a long history in that regard, and which I have the utmost respect for.
Thank you very much. I'm going to give the floor to you, Mr. Brandon.
Thank you. My first question is, when it comes to preventing deadly force by the police, do you agree or disagree that all law enforcement agencies should be federally regulated versus allowing states so much discretion when it comes to statutes regarding stand your ground and no-knock warrant laws?
I'm sorry, who's the question directed to?
Oh, I'm sorry, Ms. Lombard, you go first.
Okay. I do think that states still have to make their own criminal justice laws. The issue with the deadly force is that I think that is something we should have gotten away from a long time ago. I feel like we spend way too much money training police to be combative instead of training them to be community servants. As the judiciary, as lawyers in the public safety, in the public system, we are servants, and the police are technically supposed to be public servants too. Yes, they should have the right to protect them. They are truly in danger. But we need to be moving money away from these aggressive, combative training techniques and moving it more into service programs. We need to be going back into community policing. And I think that regardless of what state you're in, it should be a mandatory thing that you take cultural sensitivity training for whatever the cultures in your community are. Whether in New Orleans, we're predominantly Black city, but we also have a large Hispanic population, a large and Asian population. I think our police should be trained. When I was at ATC, I used to have my agents trained on cultural awareness, for the store owners in their area. And I think the police need to learn how to function with the other cultures in their community. If they're Black, they need to be trained on white and Hispanic culture. And if they're Hispanic, they need to be trained on African American and white culture. I mean, until they bridge that gap and stop being afraid of each other and stop seeing the general as their enemy, then we're never going to make progress. I think the current system and the current training system and the current funding system feeds into that. And then we have to top down. We have to start getting not going to their officers when they do something wrong. When the community sees that they can trust the police and the police sees that the community is not a danger because of their race or their looks or where they live, then I think we'll have a much better society. But that has to start top down. Our mayors, our chiefs of police, our trainings, our recruitment, all has to change the way they train and the way they look at the system.
Thank you, Ms. Lombard. Mr. Singer?
Yes, in terms of directly to your question regarding police-involved shootings or police-involved violence, yes, I strongly support federal and independent investigations of those sorts of cases, because I think that is the type of thing that does build community respect and community trust in the system. I think when you have police departments either investigating themselves or being investigated by people who they're pretty close to. I mean, even when you have the state police is broken up by districts, so the officers in a particular district are fairly close to even the local police officers in that area. So I think it is very important to have independent investigations and not have situations like you had in Ferguson and other places where you have a district attorney who is doing the investigation, who's also conflicted because the district attorney is relying on that same police department and those same police officers for the vast majority of the rest of that district attorney's cases. So in some respects, the district attorney there is not really independent. They're held hostage, they're hostage to the police department there. So I really think removing both the investigation and the prosecution as far away from the local level is important. I also think it's extremely important that we significantly reduce our reliance on police, jails, punitive measures to address social problems. We spent all of the 70s, 80s, and 90s taking all of our social problems and throwing them where the money was moving at that time into the criminal justice system. And that made drug dependency, mental illness, homelessness, poverty, all of these social problems became law enforcement problems, police problems, court problems, DA problems, and jail problems. And jail has no solutions for these problems. The police do not have solutions for these problems. What we need to do is return those problems to community-based social programs where they can really be addressed. Jail is just not the answer, and that means police arresting and bringing those cases to court is just not the answer in terms of solving the problem. We can all recognize that it's a problem if someone who is addicted to drugs breaks into a car or steals something from somebody. It's a problem, but the question isn't, is it a problem? The question is, what's the solution? And the solution, we just don't have it in the court system or in the jails. And so we need to return those kinds of situations to community-based social service programs.
Okay. Thank you. My next question is a two-part question, and we'll start with Ms. Lombard. With the amount of mental care problems in our city, how do you propose to help or improve the standards of the mental health in the city, health care in the city? And what will you do as judge to improve the standard care that will contribute to the reduction of domestic-related and violent crimes?
Okay. So as a magistrate judge, we do not control the healthcare system in the city. What we do have currently is a pretrial services system that has some limited mental health capacity, meaning there are situations being set up now where they can release a defendant that is in jail on a mental health problem to, say, Odyssey House or to another inpatient hospital. The problem with that system is we have very limited resources for that. The problem is we only screen for that. We have very limited screening. So in the pretrial system, they interview the defendants beforehand, before they ever get to the court. And they talk to them about their background. But in my opinion, they're not screening enough. That's where I came in earlier about the need to screen, not just for the charge and talk about whether the defendant has a job or not. We need to be looking at whether or not this defendant has previously been diagnosed with a mental health issue, whether or not this defendant may actually be a victim that has suffered long-term abuse. Because If somebody comes in on a drug charge and we release them simply to drug court, we're treating the symptom but not treating the problem. That's not going to change the long-term mental health issues. So we have to do this in two ways. One, give outside groups, nonprofits. There are groups here that have the funding to work with the court, because we can't fund it. I mean, let's be real, the court is already broke. But we definitely can get outside nonprofits, more of them to work with the court. We have to have a system in place. What happens to the defendant that's poor but not on Medicaid? You know, if they're on Medicaid, we can release them to Odyssey House. We have to come up with a plan to help the defendants. And when they're coming through pretrial services, we have to have a plan that's treating all the issues. If they've got mental health issues and a drug problem, then they need to be treating that. Now, we have a domestic violence monitoring system, but again, it is very limited on what they do. They do give services to the defendant, but some of their counseling services, they're charging $25 every time they go. If the indigent, he can't pay $20 every time he goes. We need to be wrapping in more, we need to be pulling in more people, doing a partnership to get more people involved, to find ways to get grant money, to find ways to fund these services. And if we can do that, I think especially on your first and second time offenders, we can stop them from getting to the point where they become repeat offenders and have to be incarcerated. We can stop them, hopefully, from committing violent crimes in the future. And most importantly, in domestic violence cases, if we can do this properly, hopefully we can stop the defendant from being a victim. And that's what I mean by balance. We have to protect the safety of the victim, but we also have to make sure that we are not holding the defendant in jail if we can be letting him out and getting him treatment. And hopefully, maybe someday, every domestic violence case doesn't have to end in divorce if it's done properly and everyone is counseled properly and the family heals. It is ultimately better to have the family unit be able to go back together if that can be done. And even if it can't be done, you have to get to the point where the parents can work together, because 90% of the time they have kids. So you can't just let the criminal justice system destroy the family unit.
Thank you. And Mr. Singer?
Well, this is certainly, I've outlined plans right on, and you can look at my plan right on my website. On my it's the third plank of my platform, which is to create a truly robust pretrial services agency, which we've never had in New Orleans. I have practiced as a public defender in a system where there was a real pretrial services agency that really that was robust and had connections to community-based treatment for mental illness. And I think that that's really important. I think, and I've written already a one-page white paper on outlining exactly what I would do in order to create this sort of system, which creates a multidisciplinary task force that can go in and interview clients before they ever get to court for first appearance, determine if there's substance dependency issues, mental illness, homelessness, and determine the level, the degree, and what programs exist in the community. I think the other thing that needs to be coordinated and that can be coordinated is over at the Civil District Court, Judge Kern Reese has implemented an AOT program, which allows family members of people with severe mental illness. Now we're talking the seriously mentally ill, where their family members can petition the court and the court can compel mental health treatment by court order. And I think if there were coordination between the Civil District Court and the Magistrate Court and the Criminal Court in Judge Kern Reese's AOT program, we could really use that as a mechanism using conditions of pretrial release that are non-monetary, even in situations where the statute may require a money bail. If mental health treatment is what's called for, a nominal bond can be set of $1 or $5, something that the person can make, but then impose these other conditions that require treatment and compliance with an AOT program from the Civil District Court, and that can be coordinated with community-based services. And as we did with the Public Defender's Office reform, I can tell you post-Katrina, there was no money. There was no money in the state, and there was certainly no money in the city of New Orleans in order to rebuild the Public Defender's Office. but yet we were able to do it. And the way we were able to do it, and again, this is where I would rely on my experience. I've actually been there and done that. So in terms of building a robust pretrial services agency, using national funders, I know exactly how to do that because I did that with the Public Defender's Office post-Katrina. And the key to doing that is outside funders, nonprofits, non-governmental funding agencies will not fund on a full-time basis what they regard as government programs, things that the government should be funding. But what they will do is fund pilot programs to get things started where you can then demonstrate that they work, that they solve problems, and that they save taxpayer money by reducing levels of incarceration. So I've actually done that in the criminal justice system. The thing I would say about domestic violence and other violent crimes is I think that a lot more use needs to be made of the availability of preventive detention. That's the second. Sure.
Sorry.
No problem.
Thank you. And my last question, in regards to criminal and prison reforms, what have you done to influence policy change? And we'll start with Ms. Lombard.
Well, one of the things, since we're talking about pretrial services, that I have done to influence policy change is Mr. Singer says he worked with the pretrial to bring pretrial services here after Katrina. We actually did not have pretrial services in magistrate court until 2011, which is when the Vera Institute came in. I was actually one of the magistrates that went to Kentucky, studied their system, did the research. There were two magistrates and 2 judges that did the research, met with Vera, and then made the recommendation to the court on how we would bring pretrial services in and how we would roll it out. Unfortunately, Vera was actually a very well-funded system in other cities and very robust. The issue here in New Orleans has always been funding. Once we brought Vera in, they actually started dividing the money between the Vera system and the criminal court system instead of the city giving Vera its own funding, which meant that all they really became at that point was a risk assessment system. But I did work hard to bring them here. As a public defender, I started off before Mr. Singer came in. I know he likes to call our system subpar, but we didn't have the funding that he had. When Mr. Singer came in, he got big grants coming in after Katrina. Before that, the public defenders were making $30,000 a year and staying in trial till 8, 9 o'clock at night because we had no money and we were overworked. There was no judges at that time. Supreme Court hadn't ruled that we shouldn't be handling more cases than we were. But we were trying everything, and I used to have to try stuff as simple as crack pipe cases because we had a district attorney's office that would upcharge a crack pipe from a paraphernalia to a felony charge just to give Black defendants a felony charge. So I worked on policies like that. I fought in the early days to help change some of the triple offender laws. And in the John Bell Edwards administration, I was part of the cabinet. So we helped push the executive package that pushed the unanimous jury bills, that pushed the felons, the rights of getting the felons back their rights to vote. And I even tried to push a bill to allow felons to own bars and restaurants again instead of waiting under the current alcohol code for 10 years. Unfortunately, I pushed that bill for 3 years. It didn't go through, which is why I say reform. Saying the word reform is great, but we can't violate the law. Mr. Singer is talking about letting violent offenders out on a $100 bond. That's all fine, well, and good, but that's really not what the law was intended to do. And more importantly, if you're talking about letting a violent offender with a mental illness out on a $100 bond, you may very well be endangering the general public or endangering the defendant's own family. I mean, this is why I keep saying you have to be balanced. You cannot be one-sided. Telling people what you're going to do as a judge before you've ever taken a bench is actually an ethical violation of the judicial code of ethics. A judge is supposed to hear every case as it comes and stand on the facts of that case. They're supposed to consider the defendant's ability to pay, whether the defendant is a risk to the general public, whether there is a risk of recidivism, whether there is a risk of flight, and most importantly, whether there is a risk to the victim. So when he stands here constantly and tells you what he's going to do as far as getting rid of bail and letting out people on $100, he is not planning to be the fair and efficient judge that a judge needs to be because he has made his decision before he ever heard the facts of the case.
Okay, that is time. Thank you so much. We have to move on.
Mr. Singer?
Yes, in terms of pretrial services, I wasn't referring to anything in New Orleans because Ms. Lombard's correct. There has been historically no pretrial services program. I was referring to pretrial services programs I worked with when I was a public defender before I ever came to New Orleans. So that's true. Now, as far as I think Ms. Lombard is not correctly understanding how an AOT program works. An AOT program, if someone were released in concert with an AOT program, somebody with a mental illness, they would be court ordered and compelled into a mental treatment program. And so there would be nothing voluntary necessarily about it. It would be a condition of release. And then the AOT program can be an inpatient program. That does not mean letting somebody with a mental illness who's a danger to the community wander the streets. What it does mean is not stick them in a cell and lock them away in a cell, which is what we currently do, where there are no mental health services. They're simply locked away in a cell, in an isolation cell, and that's it. And they're left to rot in a cell with their mental illness without adequate treatment. So what we're talking about is moving them out of a jail cell and into a mental health treatment program, and it can be an inpatient program, and it can be court ordered and mandated, even if the person doesn't want to go. So I just think that's misconstruing how the program would work. And I do think that as far as when you're dealing with violent, dangerous criminals, I don't think money bail should be used in those cases either. That's unconstitutional. Under both Louisiana and the federal constitution, setting a money bail an amount more than is necessary to have the person returned to court is unconstitutional. That's Stack versus Boyle. That's de facto preventive detention under Salerno versus United States.
That is time. Thank you, sir.
Thank you so much. We have our next group of candidates in. I want to thank you, Ms. Lombard and Mr. Singer. Good luck in your campaigns. I know it's difficult right now with COVID-19 and everything else. So good luck and good night.